Imagine if police could walk into a storage unit, open a box labeled with your name, and read all your old letters, all without a warrant, no judge, no probable cause, no warning. That sounds unconstitutional, and it is. But yet, when it comes to your emails, that's exactly what US law has allowed for decades. There's a federal privacy law from the 1980s that has a giant loophole in it that allows cops to search your old emails without a warrant. I'm Jeff Hampton, the people's lawyer, and in this video, I'm breaking down number 1, what law has this giant loophole? Number 2, how this loophole works. Number 3, how police and government agencies have exploited it. Number 4, why Congress hasn't closed it. And number 5, most importantly, what you can do right now to protect your email privacy. The law with this gaping loophole is known as the Electronic Communications Privacy Act, or ECPA, passed in 1986. Long before Gmail, before smartphones, before cloud storage, or before anyone had even heard of the word email, buried inside the ECPA is a rule so outdated it borders on absurd. If your emails are more than 180 days old, the law treats it as if you abandoned them. And abandoned property, it gets no Fourth Amendment protection. It's literally constitutional dumpster diving. That means police and government agencies can access older emails with nothing more than a subpoena, completely bypassing the warrant requirement. So how did Congress, in its infinite wisdom, decide to write in this loophole? To understand how we got here, we have to go back to 1986. When Congress passed the ECPA, email barely existed in the way that we understand it today. It was mostly used by universities, researchers, and a handful of early adopters. Storage was expensive. Servers were tiny. Keeping messages online long-term, it wasn't practical. So lawmakers made a key assumption. They believed people would download their emails and store them locally on their computer, and then delete them from their servers months down the line. Because of that assumption, Congress drew an arbitrary line of 180 days. Under the ECPA, emails 180 days old or less are considered private. Emails older than 180 days are treated as abandoned, and that distinction has had massive legal consequences. If an email is newer than 180 days, it is considered private, which means cops must now obtain a search warrant based upon probable cause and approved by a judge. But if the email is older than 180 days, cops can now obtain this email through a subpoena, which means no probable cause needed, no review by a judge, and many times you won't even know that they did it. In other words, once your email hits the 6-month mark, the law assumes you don't care about it anymore. That assumption made some sense back in the 1980s, but today it makes no sense. Most people keep days or years of emails stored in the cloud. Our inboxes contain our entire life histories, things like legal documents, financial records, medical information, business strategy, intimate conversations, passwords, and photos. And under the literal text of the ECPA, the vast majority of all that information is legally treated as disposable. This is the loophole. But if the police still have to get a subpoena, doesn't that make it a little bit more difficult to get your emails? Not really. To understand why this is so dangerous, you have to understand the difference between a search warrant and a subpoena. A search warrant is one of the strongest privacy protections we have under the Fourth Amendment. To get a warrant, police must, number 1, show probable cause with sworn evidence, which is fancy lawyer talk for having some sort of proof that you have committed a crime or might commit a crime in the future. Number 2, convince a neutral judge that this evidence is worth issuing a warrant. And number 3, be specific about what they're searching for. Warrants are meant to be difficult to obtain. That's the whole point. A subpoena, by contrast, is dramatically easier. In many cases, no judge ever reviews it in advance. It can be issued by a prosecutor or an agency, and it only has to be relevant to an investigation. Subpoenas are routine. They're cheap, they're fast, and they really don't need much justification. And the worst part, subpoenas are handled quietly. When a subpoena is sent to a third-party provider, Like your email service, you often won't even know it happened. The ECPA technically requires your email service to notify you, but that notice can be delayed, and often it is. Authorities can apply for gag orders claiming things like ongoing investigation, a risk of evidence destruction, or national security concerns. Those gag orders can delay notifications for months or even years, so police can quietly obtain your emails, read through them, copy them, and store them, and you'll never know it. You don't get a chance to challenge the request. You don't get a chance to assert your right. You don't get a chance to object in court. That's why privacy advocates call subpoenas a backdoor around the Fourth Amendment when it's used for email content. So, are any email providers fighting back? Unfortunately, this loophole gives law enforcement access to entire email archives. Think about what that means. Instead of investigators asking for specific evidence tied to a specific crime, they can now ask for every email in an account spanning years, covering personal, professional, and unrelated topics. This would normally be forbidden under the Fourth Amendment as an overrode search, but under the ECPA, it's allowed if the emails are old enough. Former prosecutors have openly described the process as a fishing expedition. When investigators subpoena a provider, the request can be as broad as they want. The provider isn't required to evaluate relevance or necessity, they just comply. And providers almost always comply. Why? Because number one, subpoenas are lawful orders. Number two, non-compliance carries penalties. Number three, providers aren't the ones whose privacy is at stake. And finally, number four, challenging subpoenas can be very expensive. It usually doesn't make economic sense for email service providers to fight these. As a result, your email service is unlikely to protect you even if the request is overbroad. Looking at transparency requests shows how common these requests are. Major tech companies receive tens of thousands of these government data requests every year. Between 2014 and 2024, U.S. agencies obtained data from millions of user accounts across major platforms. Email access is no longer rare, it's routine. And what's worse, emails less than 6 months old could still be included in these phishing expeditions. The ECPA has another flaw that distinguishes between, quote, electronic communication services and, quote, remote computing service. Courts have interpreted this to mean that once you open an email, it may no longer qualify for protection, even if it's less than 180 days old. So, if you open a message and leave it in the inbox on your servers, authorities will argue it's being stored like a file, and files get less protection. This interpretation was adopted by at least one federal appeals court and echoed by the Department of Justice at one point. But surely someone has argued this in front of the Supreme Court almost. All of this came to a head in a landmark case known as United States versus Warshack. Federal investigators secretly obtained around 27,000 emails from the suspect's account, all without a warrant. The emails spanned a period of 2 years. The owner, Steve Warshack, wasn't even notified at the time. He only learned later that the government had accessed years of his private correspondence. And since the ECPA requires notification, Warshack challenged this collection of his emails in court. And in 2010, the Sixth Circuit Court of Appeals issued a groundbreaking ruling. The court held that people have a reasonable expectation of privacy in their emails. Emails are equivalent to letters and phone calls. The Fourth Amendment requires a warrant to access them. And ECPA's 180-day rule cannot override the Constitution. In plain language, the court said this law was outdated and the Constitution wins. This was a huge victory for digital privacy. But there was a catch. The ruling was not given by the Supreme Court. So, it did not change everything for every state. Instead, it only applies to the states in the Sixth Circuit Court of Appeals: Kentucky, Michigan, Ohio, and Tennessee. And unfortunately, there has never been a Supreme Court ruling settling this issue nationwide. But wait, surely Congress has been able to do something about this, right? Not yet. After wars, the Department of Justice quietly changed its internal policies. Federal agents now generally try to obtain warrants for email content. Major providers also started adopting warrant-only policies for email access. So you think now the problem is solved? It's not because ECPA itself has never been updated. The loophole is still written into federal law. That means smaller agencies may still attempt to use it. Civil regulators can still rely on subpoenas. Policies can change overnight, and providers can change their standards. Oh, and don't forget about metadata, sender, recipient, timestamps, IP addresses. These receive very little protection under ECPA. The system now relies on voluntary restraint, and voluntary restraint is no guarantee of privacy. But what about Congress? Hasn't anyone up there tried to do something about this? For more than a decade, lawmakers have tried and failed to fix this. Bills known as the Email Privacy Act were introduced repeatedly from 2013 to 2020. They would have required warrants for all email content, regardless of the age of the email. The House passed these bills unanimously, multiple times, bipartisan, no controversy. But then they died in the Senate. Why? Because amendments were added that created carve-outs. Carve-outs like emergency exceptions, national security letter expansions, and metadata loopholes. Privacy groups called these poison pills. The bills stalled, committees then delayed, and sessions ended. And nothing has changed, which means still to this day, a law that was written before Jurassic Park even hit theaters still governs cloud email privacy. Now, some states like California have stepped in with stronger protections. But remember, state laws don't bind federal agencies. But I know what you're thinking, Jeff. Should I really worry about this? Think about what's in your inbox. Not hypothetically. Let's actually think about it. Contracts, medical records, personal struggles, financial history, legal advice, business plans, private photos. Now imagine all of that sitting on someone else's server. And imagine the government can request it privately with paperwork that never sees a judge, even if you're innocent, even if you're never charged, even if you never find out. This isn't about protecting criminals, it's about protecting everyone. Because privacy, it isn't about hiding wrongdoing, it's about limiting power. But here's the good news, you're not powerless. And here are the specific steps you can take to protect yourself from cops spying on your email. Number 1, use end-to-end encryption. If your provider can't read your emails, neither can the government. Use PGP or encrypted email services. Encryption ensures the provider only has unreadable data. Yes, it's less convenient, but yes, it's also worth it. Number 2, delete or archive old emails offline. If emails aren't stored on a third-party server, they can't be subpoenaed from one. Download old messages to a local device, then remove them from the server. Your personal hard drive, it gets Fourth Amendment protection. Number 3, choose privacy-focused providers. Look for email service providers that provide the following: encrypt data at rest, require warrants by policy, publish transparency reports, and operate under strong privacy laws. Number 4, use POP3 with delete after download. This automatically removes emails from the server after retrieval. No long-term cloud storage. No 6-month archive waiting to be searched. Number 5, use alternatives for sensitive communication. Unfortunately, email is fundamentally insecure by design. For sensitive conversations, consider encrypted messaging apps that don't store content centrally. For example, consider using apps like Signal or WhatsApp. And finally, number 6, stay informed and advocate for privacy reform. Support privacy reform. Follow digital rights organizations. Know your rights. Your silence only benefits more surveillance. Now that you know an ancient email law opens the door to government snooping, what if your phone becomes the snitch before you even hit send? Watch this next video, where I break down how what's known as client-side scanning will turn your phone into a surveillance tool and the exact steps you can take to stop it. See you over there.